Yes, Mr. Rivet.
My Lord, my Lords, I appear on behalf of the appellants in this matter, together with Mr. Elliott, my learned friend, Mr. Stone, and Mr. Darajawala appear on behalf of the Commissioners of His Majesty's Revenue and Customs. My Lord, if I may, just check a little bit of housekeeping.
Yes, please do.
So I hope the court has received copies of the core bundle and the principal authorities bundle.
Yes.
It should also have received a supplementary bundle, which contains a few of the underlying contractual contracts. Yes. In addition to that, there's a short supplementary authorities bundle filed by HMRC.
No, I don't think.
And we haven't
I think there may have been a misstep somewhere. I hesitate to work out where there's been a disjunct. What we were going to say in relation to that is, certainly from my perspective, I won't be turning to those authorities for a while.
Right.
And there's also a short little clip of some authorities that we put in yesterday that are referred to in the underlying judgments. I understand.
We've got that. This is Wensleydale settlement.
Precisely, my Lord.
Yeah.
With your leave, I wondered whether it might be convenient for your lordships if we actually combined HMRC's supplementary authorities bundle with our one and gave you a single one.
I'm sure that's sensible, yes.
Thank you, my Lord. And we'll bring hard copies so that they're here at some point immediately after the adjournment, if that's of assistance.
Yes, but if we crack on. But that's comforting that we've got at least what you thought we had for yesterday. I'm sorry it's so cold in here. We were warned before we came in, and immediately you come in. It's the opposite of getting off the plane in Mauritius.
Well, my Lord, you may be grateful for that after lunch.
Yes, there we go. The other thing that crossed our mind was just to really manage our expectations as to the time estimate.
Yes.
Have you been able to discuss it with each other? And
we have, my Lord.
This is important, and you take as much time as you need, but I just was inquiring as to whether you'd decided 2 days was all going to be needed.
At the moment, I believe we think it will be, my Lord, simply
Right.
because there's quite a lot of law to get through.
Yes, there is.
But we'll keep that under review. My ambition is to finish at some point mid-afternoon today to let my learned friend start.
Yes.
To leave me times more afternoon to ensure that I can reply on the points of law that arise from the submission.
But we'll see how we go. Yes. And you can take it that we've certainly read the essential core materials. Some of us will have read more widely than others, and some are more familiar than I am with the topic.
Well, can I signpost the structure that I was proposing to adopt? Just in overview, subject to your lordships wanting me to take things in a different order. I was going to start this morning, although this is set out in the skeleton arguments, just by focusing for a short period of time upon the legislative framework of this. Simply so that one can get one's eye in when it comes to some of the discussion that's made in the authorities in due course, and to make various propositions regarding the effect of double tax conventions as a matter of English law and the way in which they become part of English law. The second thing that I was proposing to do is to make my positive case as to what we say the test is for poem in the context of Article 4.3 of the treaty here in question. It's in our skeleton argument. We made the same point before the Upper Tribunal, but I will articulate it again before your lordships, and then I hope to make good by reference to principle, by reference to orthodox methods of construction, and by reference to authority, why I am right as to that test. I will then, at that stage, turn to Smallwood, which I need to address, because that was the obstacle that was put in my path before the Upper Tribunal. But I would not want your lordships to think that I was not going to address you on Smallwood. I will deal with it at very great length. Just from a presentational perspective, I think that it makes more sense to put my submissions in context as to what Smallwood is not saying, having established in the first instance what I say as a matter of law is the correct test. And a criticism that is made by the appellant in this court and was made before the Upper Tribunal is that, with the greatest of respect to my learned friend's case on the other side, there is not a clear articulation of what the test is for poem in the context of Article 4.3. That's not an ad hominem attack. I don't criticize my friend for that in any way. It is that one of the principal stays of my submissions is that the case advanced by the Crown in this matter is unworkable. and I will come back to that in the course of my submissions in due
They
course.
say your case is unworkable, so the parties seem to be ideum at that.
That's right, my lord. We wouldn't be here, I think, were that not the case. But a key point is that we do have a positive test to offer you, supported, we say, by orthodox methods of construction. So if I could start really with the legislative framework. Yeah. First of all, again, this is set out, this is rehearsed in great detail, both before the courts in Smallwood, but also before the FTT here and in the Upper Tribunal. But there are a few points that I would like to draw to your Lordship's attention as to how that operates. The legislation is in the bundle. Now, what we've done is, with one little wrinkle, which I'll come on to in due course, the legislation from a domestic perspective that you have in your bundle is the domestic legislation that was in force during the years in which the events here in question were affected. Life has moved on in quite a number of material ways since then, and I'll draw a couple of those to your Lordship's attention, simply just by way of context, not because I carry any favour from those amendments, but just so that your Lordships have the full scheme of how it fits together. The starting point is, under the terms of the Capital Gains Tax Code, if I could ask you first to turn to the scheme for the taxation of the trustees of settlements. And if you could turn, please, I wasn't proposing to take you to the charging provisions for capital gains tax purposes. They're set out in the decisions below. But just to explain the nuts and bolts of how trustees are treated for capital gains tax purposes domestically, before we move on to the treaty, which is what the case is about. So if we turn to section 69 of the Capital Gains Tax Act, Capital Gains Tax Act 1992, on page 16 of the bundle. Trustees of settlements. Subsection 1, in relation to settled property, the trustees of the settlement shall, for the purposes of this Act, be treated as a single and continuing body of persons, distinct from the persons who may from time to time be the trustees, and that body shall be treated as being resident and ordinarily resident in the United Kingdom, unless the general administration of the trust is ordinarily carried on outside the United Kingdom, and the trustees, or a majority of them, for the time being, are not resident or not ordinarily resident in the United Kingdom. Now, just pausing there, it is common ground for domestic purposes between the parties. It has been, it was before the Upper Tribunal as well, that the general administration of these trusts, within the meaning of section 69, was during what I shall call the period of the Mauritian trusteeship, conducted in Mauritius. I have spent quite a lot of time, and so have my juniors, trying to provide some articulation from the courts as to what is meant by the general administration of a trust for these purposes, for the obvious point that there is a distinct, that the way that the authorities have emerged below and in Smallwood as such as to draw a distinction between the general management and the place of effective management in the context of the treaty. And I thought it would be helpful to provide your lordships with an explanation of what that meant in domestic law. I'm afraid we've drawn a blank. There does not, to the best of my research, appear to have been an English case that's considered that meaning in this context. It is noteworthy, however, I can't make this good by empirical evidence, but the context of general administration of a trust is quite regularly incorporated within trustees, the trust instruments as a term. It seems to be one of those phrases that is so familiar to practitioners that it's never been debated. But I have not found one, and if my learned friends' endeavours are able to find one, then we'd be grateful to see it, but I thought I should register that.
But before we leave section 69,
yes, my lord.
It's this provision which Lord Justice Hughes particularly relied upon. It's the one he quotes.
That's exactly right, my lord.
And he particularly focuses on, it's the second sentence, the way it's set, or the second line, a single and continuing body of persons.
That's right, my lord.
And no doubt you'll come to that when you come to Smallwood, but this, for our purposes, this
exactly
would be a very important provision.
That's exactly right, my lord, which is why I took you to it. Lord Justice Hughes is focusing upon the fact that over the course of the same tax year, the trustees, the properly appointed and constituted trustees of the settlement, were a single body of persons, but for a period of time were in Jersey, and then they were in Mauritius, and then they were in the United Kingdom. And that is the focus of Lord Justice Hughes's judgment, my lord, and I will come to that in great detail in due course, if I may.
Yes.
Just to show you another piece of plumbing, not actually relevant, I think, to the issue that's for your lordships, but so that you've got the context of how these trusts are taxed. You will have seen in Smallwood there is a discussion about the distinction between Section 86 and Section 877 of the settlement. We are concerned, in this case, if we could turn to it on page 18, with a charge that arises under Section 77. Now, the reason that was important in the context of our case is as follows. Section 86 applies to settlements in circumstances where trustees are, for domestic purposes, not resident at all during the course of the year. And in old terms, the legislation works slightly differently now. But in the way the legislation used to work, in circumstances where Section 86 applied to a settlement, a settler was chargeable depending upon their domicile status, on the gains realised by the offshore settlement on an arising basis, subject to various other wrinkles. There was a subsidiary provision, Section 87, which is still in force today, but in materially different terms, which said that in circumstances where you had offshore trustees and you weren't taxable on the settler because one of the gateway provisions under Section 86 didn't apply, then the gains were visited upon beneficiaries as and when they received capital payments, as it's described by the legislation from the trust. We have a similar regime now. It's actually been quite largely rewritten in the course of the last few months with the changes to the non-domiciliary regime. But the broad structure of it is that when you look at the judgments and they're talking about Section 86 and 87, they're dealing with a different regime. The reason why in these circumstances it was deemed important that we were a Section 77 case is that in circumstances where you have a Section 77 case, you do not have the Section 87 charge on beneficiaries on gains when they're distributed out of the settlement. I hope that's clear. This is, I hasten to add, simply for context, because when we come to look at Dr. Avery Jones's, the Special Commissioner's decision in Smallwood, he not on our point, on the first point, focuses upon the distinctions between 86 and 77. But what we're concerned with in this case is Section 77, the Chargeable Gains Tax Act. Now, the important point here, if we look at the terms of Section 77, where in a year of assessment, chargeable gains accrue to the trustees of a settlement from the disposal of any or all of the settled property, that's us, then subject to a deduction, and that's a deduction to deal with losses and things, it's a quantification provision. At any time during the year, the settler has an interest in the settlement. So that's two of our settlements here in question. That's the GH settlement and the IL settlement of 1991. It isn't the discretionary settlement from which the settler was excluded. So two of our settlements are this provision. The trustees shall not be chargeable to tax in respect of those, but instead chargeable gains of an amount equal to that referred to in paragraph B shall be treated as accruing to the settler in that year. So for two of our settlements, if and insofar as you are for domestic purposes deemed to be resident during part of the year, or chargeable during part of the year, then those gains will accrue on the face of matters to the settler. For the discretionary settlement, the S&A trust, they accrue to the trustees themselves. One little wrinkle, just for your lordship's further context. You need to see subsection 7, which of course they refer to in the judgment. Section 78, there is a right of a recovery on the part of the settler from the trustees. And one, it's not a material point, but one of the points that's made in by the FDT in the course of its judgment, it isn't material, is that it is said that the economic benefit of the CGT planning here in question fell to the settlers. But the effect of the Section 78 is there's a right of recovery on the part of the settler against the trust fund anyway. But nothing turns on it. It's just so that you've got the context. So just so that I I think I've set out in the skeleton argument the periods during which it's common ground as to when we would, the general administration of the trust was carried out during each of the periods here in question, the times of each of those. The next thing that I thought I should just turn you to is the provisions of how the double tax arrangements are given effect in England. If you turn to page 31, this is the gateway into the terms of a double tax convention or unilateral relief in circumstances. We're not concerned with that here. Double taxation relief is given effect to for capital gains tax purposes. It is expressly incorporated. Your lordships will have seen this in other cases. I know that at least I think 2 of your lordships have seen this in income tax cases. The relief has to be expressly incorporated into the legislative regime to take effect in England, to override our domestic provisions. That is the machinery contained within section 277. So subsection 1, for the purpose of giving effect from double taxation in relation to capital gains tax and tax on chargeable gains, etc., relief may be provided. Any arrangements set out in an order shall, so far as they provide for relief from tax chargeable in the United Kingdom on capital gains tax, capital gains, have effect in relation to capital gains tax. And then there's some other mechanisms there, but the important provision for these purposes is section 277. The courts below, the FTT in its decision, we don't need to turn it up now in due course, explains a little bit about how the Mauritian income tax works there. To make the obvious point, Mauritius did not choose to tax the gain here in question. And that's set out with some detail in there. A slight, it's not a criticism of the FTT. I hope you could take judicial notice of it, but I will. I could make it good by reference to the domestic English statutory provisions. The English tax year runs from the 6th of April each year. The FTT doesn't make any findings about the dates on which the Mauritian tax year run. There was actually some evidence before the FTT on those. I don't want to infect the purity of our appeal by going back to all of that. But if your lordships were interested anecdotally as to what the date of the Mauritian tax periods here in question were, we can give you the references to that in due course.
What is the relevance of that?
Well, my lord,
you raise a tantalising question, which appears to be of no relevance. So why tantalise us?
I tantalise you on this way, my lord, because in due course I'm going to submit that one needs to identify with some accuracy the period, the relevant decisions that are made by the relevant persons for the purposes of ascertaining the Poem test. And one of the points that I will make in relation to whatever test can be identified from Smallwood or from the FTT or from my learned friend's case is that it is not capable of universal application because of, in particular, the asymmetries that operate across the world on different tax years and different periods of assessment. And I will make the submission in due course. Certainly, so far as this treaty is concerned, I don't need to go any further than that. That poem has a meaning which we say is capable of uniform application, irrespective of the terms of the period in question. I am not challenging the snapshot approach of that was rejected in the Court of Appeal to the ascertainment of residence. That was the fight in Smallwood. But for context purposes, all of the first bits of the judgments that we will look at when it comes to Smallwood, Lord Justice Patton in particular, is concerned with snapshot. And that snapshot question arises precisely because of the asymmetries in the taxation periods for these years. I hope that's helpful, my lord. It is simply to make the obvious point that not everybody has the same tax year as us, and double tax treaties have to work in those circumstances.
That would be true whether or not the FTT had made a finding as to the Mauritian tax year.
Oh, I agree. It's
a legal argument.
It might.
So we didn't need to be tantalised as to what the factual position was or not.
I apologise, my lord. I will resist the temptation for it. It is not part of my argument. It is there simply in case your lordships wanted the information as to what the tax year was for Mauritius. But I apologise for the diversion. So the Mauritian tax is set out in some detail there. If I might now turn, please, to the implementing provisions under the domestic rules for the incorporation of double tax relief. This is important, I say, and I say I will develop this in due course because of the discussion that comes on due course within the, if you like, ambulatory use of commentary that arises after the date on which two parties contract bilaterally to agree the terms of a treaty. And the point I'm going to make and develop in due course is that the double taxation arrangements here in question are arrangements that are incorporated into our tax code by statutory provision. They are laid before Parliament and subject to negative ratification on it. It is not the set of circumstances which you sometimes see in the tax code, where Parliament says to the Treasury, here's a power, an enabling power, you go off and do what you like with it and change your view from time to time. And I will develop that in due course when I come to look at the terms of the treaty, my lords. But let me just show you the provisions so that you've got
which page would you like us to go to?
Yes, my lord. So if you could turn to the terms of section 788 of the Taxes Act, which is in page 7 of your bundle, tab 2 if you're using the paper bundle. And what subsection 1 says, if Her Majesty by order in council declares that arrangements specified in the order have been made with the government of any territory outside the United Kingdom with a view to affording relief from double taxation in relation to income tax, corporation tax, or any taxes of a similar character to those taxes imposed by the laws of that territory, and it is expedient that those arrangements should have effect, then those arrangements should have effect in accordance with subsection 3. And then if you look down at subsection 3, we see the provision that then, as it were, moves into 277 of the Capital Gains Tax Act that I've shown you. Now, just for completeness, this is the piece of legislation that provided relief from a domestic perspective as at during the tax year here in question under the Income Taxes Act 1988, so in 2000-2001. Just for completeness, this was a rewrite of the legislation, as your lordships will be aware. At the time at which the treaty was initially agreed between Parliament, the relevant income tax that gave effect to it was the 1970 Income Taxes Act, and the equivalent provision in the same terms as that contained within 788 of this enactment is contained within section 497 subsection 8 of ICTA 1970. So at the time the treaty is entered into, the period at which the 81 treaty is given into, the enabling provision is that contained within 4978. The copy that you have in the bundle, I think rightly, is the copy that gives effect during the tax year here in question. Now, if I could ask you then please to turn to the terms of the treaty itself, or the order, I should say, that reflects the terms of the treaty that's been agreed. This is at tab 4 of your hard bundle.
Just before you move on,
yes, my lord.
You said this has to be laid before Parliament.
Yes, my lord.
That's subsection 10, is it?
Indeed it is, my lord.
Yeah.
I apologise, I should have taken you to that. We'll actually see that now at the front of the order that we're about to look at. I hope this is not. I'm simply laying the groundwork for submissions that I shall make in due course about the significance of this point.
Sorry, I thought you said it was negative resolution. Subsection 10 looks like positive. Order shall not be submitted unless an address is presented to Her Majesty by that House, praying that the order be made.
I apologise.
I mean, that's stronger from your perspective.
It's stronger, it's better, yes, I'm grateful, my lord. Yeah. In any event, as your lordship, in fact I can remember, will be aware, my basic point on this is a set of provisions that are subject to the approval of Parliament.
Yeah.
And I'm grateful to your lordship for that. So, page 39. Tab 4. And we see actually reflected in the terms of the order, whereas a draft of this order was laid before the House of Commons in accordance with the provisions of section 4978 of the Income Tax Corporation Act 1970. That's, I think, the equivalent of the provision that my Lord Justice Arnold has pointed to in the later Act, that refers to the 497 that I'd already referred your lordships to as being the legislation then in question. and an address has been presented to Her Majesty by that House, praying that an order may be made in the terms of that draft, then Her Majesty, and all of the powers, orders as follows, which is effectively the provision of these double taxation.
Yeah. Then we have the schedule.
My Lord, I wasn't proposing to take you through the entirety of this, but I was just going to show you the operative provisions, which will be very familiar to your Lordships, given the terms of the skeletons and the cases below, but just so that you've seen them in this section of the legislation. So the first thing that we're concerned with is the identification of what's meant by a resident of the treaty. To make the obvious point, double taxation conventions, and in circumstances where they don't work, unilateral relief, can do one of two things often. One of which is it can grant credit for foreign tax paid. The other, it can switch off the right of a particular state to deal with it. The peculiarity of this state, of this provision, we'll have a look at it in due course, is that it switches off the state, it allocates the sole rights of taxing to one state. And if the other state chooses not to exercise it, then that's its choice. Looking at Article 4, subsection 1. For the purposes of this convention, the term resident of a contracting state means, subject to the provisions of paragraphs 2 and 3 of this article, any person who, under that law of that state, is liable to taxation therein by reason of his domicile, residence, place of management, or any other criteria of a similar nature. The terms of resident of the United Kingdom and resident of Mauritius shall be construed accordingly. To make the obvious point, different states have different ways of identifying who's resident for the purposes of the tax code. We, as it happens in England, have changed domestically the way we approach that for individuals and trustees over the years. We've actually also changed it for corporate levels at some points in the course of our history. Mauritius has a different system as to how it identifies residents. And so the gateway departure point of this is that in order to get yourself within the terms of the treaty, in these provisions, we wouldn't be looking at the tiebreaker were it not the case that both England and Wales and Mauritius at the time treated the body of trustees, the person,
As being resident.
as being resident
at different times
exactly
in each country.
Is Scottish law different?
I do not believe it is, my lord, but I'm hesitant, given the custodian, because for tax purposes it's exactly the same, but I'm hesitant to go so wide as that. I believe it's the same because for income tax and capital gains tax, for most income tax and capital gains tax purposes, they're treated the same. You get some wrinkles with things like partnerships, for obvious reasons that Scottish partnerships are different to English ones. What we are concerned with here, subsection 2 is dealing with circumstances of individuals, so it's not us. Subsection 3 is what this case is about, where by reason of the provisions of paragraph 1 of this article, a person other than an individual is resident of both contracting states, then it shall be deemed to be a resident of the contracting state in which its place of effective management is situated. I will come in due course to explain some of the context of that provision, both in terms of the UK and Mauritius, and you can see that being dealt with in the Special Commissioner's decision in Smallwood as to where it came from the 47 treaty which preceded. The terms of this was changed. But I'll also, and my learned friend will also take you through, over the course of the next day or so, some of the iterations that have gone for the OECD model treaty, upon which a number of bilateral treaties are concerned. For present purposes, though, we're concerned with Article 4.3. Hope so. We'll turn into course. And then, just for completeness, Article 13, subsection, is the article of the Double Taxation Convention, which deals with capital gains. So that's us. Here, capital gains were on the face of matters realised on the disposal of the shares here in question.
Yeah. And this is my ignorance. Under Article 4.3, the tiebreaker is to look at the place of effective management.
That's right, my
poem. Is that particular to this piece of legislation, or is that a term of art that's readily
well, my lord, that's
understood?
That is the importance of this case. The place of effective management, it has. I'm very nervous, and I want to make sure that I'm fair to my learned friend in answering this question. and he may, so this is not, to put it neutrally, the terms of this provision, as here identified, reflect, as you will see from Smallwood and from the decision below, the terms of the OECD Model Treaty of 1977.
Right, so they're drawn from a mothership.
It was drawn from a mothership,
Yeah.
save for the fact that Mauritius has never been a party to the OECD. And that becomes important because when you come to look at some of the text in the commentary about the relevance of subsequent amendments to the terms of the commentary, you need to, we'll need to bear that in mind, but I'll make that good in due course.
Thank you.
But the second part to your question, my lord, is, I think the question that you're asking is this of isolated relevance to this case? The answer to that is, I will have to accept in due course that the logical consequence of what I say is the proper approach to the construction of a bilateral treaty between two parties, and that it is perfectly possible that two contracting parties to a treaty who have the same words of this might, in the context of a different negotiation, have reached a different conclusion in law by reference to the admissible materials as to what that meant. I have to accept that. Let me give you an example.
Sorry, you've just made a statement which I'm not following. I mean, this seems to be an important point, but I'm struggling to understand your meaning.
Well,
I'm sure it's my fault for being dense.
No.
Could you say it again?
That is not something I would say. My lord, I am in due course going to advance to you the proposition that the proper means of construing this provision is to look at the language and context and to look at the admissible sources of material at the time at which this was entered into, one of which was the terms of the 1977 Model Treaty, which expounded the British view as how this provision works. And indeed, the commentary in relation to that applied to all of the OECD model treaties that were based upon that. Now, I accept, however, that my construction of the terms of Article 4.3, and I will submit in this, consistent with high authority from the Supreme Court in relation to this, depends upon the intentions of the parties to the terms of this order. So let me give you an example. If in Xanadu and the United Kingdom enter into a treaty which incorporate the terms of Article 4.3, and at the time of the, we have a dispute as to how you should construe Article 4.3 in the context of the Xanadu Treaty, and at the time of that, an admissible aid to construction demonstrated that both Xanadu and the United Kingdom said that place of effective management means the place where you've got the trustee with red hair, then you might have a different conclusion to how you could construe that treaty to that which applies in these circumstances. It doesn't, in practical terms, make any difference to the resolution of this case, but I have to accept it's the logical corollary of my position that this was a bilateral negotiation and that you couldn't thereby, for reasonable law.
Okay, but I'm still struggling to understand what the relevance of this is. Is it your submission that the meaning of the words place of effective management in the context of this convention is different to its meaning in the OECD model?
No, my lord. My case is it is exactly consistent with the meaning of the OECD model.
So we don't need to be concerned with the possibility of there being a Xanadu variation.
We don't, my lord. But when we come to look at the commentaries, one of the things that you will see in some of the later commentaries, the commentary expounds what the parties to the OECD, how they think that treaty provisions should be interpreted at different points in time. And one of the points that is made against me, and one of the criticisms that I will advance against the Special Commissioners in Smallwood, is that they proceeded to construe the provisions of Article 4.3 by reference to the 2000 commentary to the treaty, not by reference to the 1977 commentary to the treaty, which was in different terms. And the reason that is important is that my learned friend will take you to some commentary contained within the OECD Model Treaty that says, look, in circumstances where parties to the OECD Model Treaty, if you like, or member states of it, change their interpretation of things, it's perfectly legitimate to have regard to the change of interpretation in the construction of things. It's not quite put in those terms, but we'll look at the text in due course. My point here is in these circumstances, there is no protocol, which is typically how these treaties are agreed, between Mauritius and the United Kingdom, which varies the terms of the meaning that was in place in 1977 when this was agreed. And Mauritius is not a party to the OECD and didn't feed into any subsequent iterations as to how it might be interpreted differently in later years. Now, that being the case, I will submit it is not legitimate to construe the consensus of the OECD models as reflecting Mauritius's view as to how you interpret this treaty as at 1977.
So to be clear, on your case, the words place of effective management could mean different things in different bilateral treaties
I'd have to accept that,
between different parties at different times.
I'd have to accept that. Yeah. But in these circumstances, as it happens, I will make this good when we come to look at the way the commentary evolves over time. I'm not sure that actually the subsequent commentaries necessarily, well, we'll look at those in due course, better to make that by reference to the documents. But the point I'm going to make in due course is that the fundamental error, the sheath error that undermines the entirety of the approach of the Special Commissioners in Smallwood, is that it disregarded the principal source that it should have looked at to construe the provisions of the 1981 treaty, which was the commentary that showed our public view as to how this should be construed at that time. And as a result of that, everything that came after it has gone off on a tangent. Yeah. But in a sense, I hope that I hope I'm not saying anything controversial in this. The Double Taxation Convention is a contract, it's a bilateral agreement, as we're going to see from the Supreme Court cases in these. It's not uncommon that you have two parties who, multiple parties enter into agreements between them. They have the same words in the contract, but they mean different things in different contracts. That's the effect of the approach to contractual construction, and I will make that good by reference to some of the authorities in due course. Sorry, my lord, I hope that was probably expansive.
My question stimulated.
Well, my lord,
yes,
that is the centre of this case. That's that. So, just to look at the terms of Article 13.4 before moving on this. This is covered elsewhere, but the crucial point is capital gains from the alienation of any property other than that mentioned in paragraphs 1, 2 and 3, and we're not any of those, should be taxable only in the contracting state of which the alienator is a resident. And that's the provision that disapplies the ability of the United Kingdom to tax the gain here in the event that the tiebreaker to the treaty contained in 4.3 deems us to be a resident of Mauritius, as we say is the case.
Yes.
So, if I may then move, I hope that's set the context for the legislative regime. I will develop this, of course, in the course of my submissions. Yes. What I was proposing to do next is, in a sense, to answer the point that your lordship has just asked, and my Lord Justice Arnold has been pushing me on, which is to articulate what I say is the proper meaning of poem in the context of Article 4.3 of this treaty. We've set this out in our skeleton argument, but just to reiterate it, I mean, your lordships will have seen it in paragraph 36 of our skeleton argument. We say the place of effective management for the purposes of Article 4.3 of the treaty between the UK and Mauritius in force at the relevant time is identified as the place in which the relevant decisions are made by the authorised decision-making body, in this case the trustees, qua trustee, of the various trusts, unless that decision-making function has been usurped during the relevant period, once properly identified, or in respect of the relevant decisions, once properly identified, or that some person has dictated those decisions to the authorised decision body. Now,
has something gone wrong grammatically in that? Since obviously this is key as your test. So it's unless the decision-making function has been usurped, or that some other person has dictated. Should the that be omitted?
Unless that decision-making function. So,
unless that decision-making function has been usurped, or that some other person. The second that should come out, should it?
Well, before we get to that, there seems to be three possibilities here, because there's two ors.
Yeah.
So have I read that correctly? You're,
or. Yes, my lord.
So you allowing for three, as it were, exceptions to the rule that you're proposing.
Yes, my lord. What I'm in broad terms.
But that's what gives rise to the grammatical confusion. Because what's the second one then? Because the second one is or in respect of the relevant decisions once properly identified, and then what?
Maybe the second one is really saying in rather less saying by focus to the decisions. It's just qualifying the first bit of it during the relevant period once you've identified that, or in respect of the relevant decisions. So
there's usurpation, two species of usurpation.
Yeah, exactly.
Yep.
I see. Right.
You might, for example, let me give you an example of that, my lord. Let's assume, for the sake of argument, that the relevant period we're testing of June of relevance is in 2025. But actually, the usurpation has gone, the hands are bound from 2024. That may have a bearing upon it.
And sorry, just before you go, just so as we got your submission clear before we get into the details. The word "those" is italicized so as to emphasise it, and what's the significance of that, please?
Because one of the criticisms that I will make of the terms of the we're not going to. Our case doesn't depend upon the facts of the FTT. We just say they got the wrong test, but we say you have to focus upon the right decisions, and that's a point that's made absolutely clear by the Court of Appeal and by Mr. Justice Park in Wood and Holden. You cannot test where the place of effective management is by asking a serious question about who was making other decisions that didn't fall to the trustees themselves. Yeah. And that is what breaks, where with respect, the Crown's case breaks down.
And to be clear, this test as propounded in that sentence is really the same as the CMC test.
My lord, it's your test in development securities. But we put it less elegantly. Yes, it is, we are saying, and I'm criticised for saying I have to acknowledge that linguistically, because most of the cases dealing with CMC are dealing with companies, there are linguistic nuances and legal differences between the way trustees make decisions and companies make decisions. Not that we say are material, but for these purposes. But in practical terms, what we are saying is that place of effective management in the context of this is the CMC test. And we've used the words Wood and Holden as the shorthand for that, because as your lordship identifies in development security, every time the facts arise, there's a nuance in some circumstances, instruction in your case, in development security's case. But in substance, we are saying, you look at the body who is charged with making the decisions, and unless somebody else has dictated those decisions to them, and they don't really make the decisions, or they usurp, you've got shadow directors or trustees de son tort, that will be the place where the effective management is. And it's a piece of law that has been part of English law for over a century. It is well familiar to the courts. And we say, and I will make this good in due course, that is the test that the United Kingdom was advertising as its test at the time at which it entered into this treaty.
And so this formulation in the first half of paragraph 36 of your skeleton is the test that you say.
That is the test that I push for.
That we should endorse.
It will probably frustrate my learned friend, but just for ease of reference, I will refer to it as the CMC test or the Wood and Holden test, but that's simply as shorthand. But I hope that's clear. And one of the points you will see, I will deal with it in due course. The special commissioners in Smallwood say, well, CMC is looking at a different thing to poem. and I will deal with that in due course.
Thank you.
But when I talk about Wood and Holden or CMC, that's what we're talking about. Now, so first of all, if I could just take your lordships, I appreciate these will be very familiar to you, but to before I make good how the construction of this particular treaty, I think I should just show your lordship some of the authorities from the Supreme Court and elsewhere that have dealt with how you construe treaty terms for these purposes, set in context my submissions. And we could start with, please, by turning to Anson in the Supreme Court. And you'll find this in tab 13 of your paper. My lords, unless you would like me to do so, for some of these points, I was not proposing to take you through the detailed exegesis of the tax arrangements there in question, but simply to show you the points of principle, if that was acceptable.
Yes.
I'm very happy to explain the context.
No, well, if we need to go more deeply, we'll say.
Thank you, my lord. So the passage upon which I rely, if one could turn on, please, to Lord Reid. And if one starts on 3, so we don't need to look at facts of that. Lord Reid starts out on page 379 of the internal bundle. That's our bundle numbering, not his point. With the Vienna Convention on Treaties. We'll look at this in due course, but just simply to set in context that those principles applied to this, although, as it happens, it was agreed after this. But we'll see that worked out through Smallwood. If I could ask your lordships, please, to read just paragraphs 54 and 56 of that judgment. So these provisions will be very familiar to the court, but I will expand upon them in due course, because I will say in due course that with the greatest respect to an extremely eminent Special Commissioner in Smallwood, he didn't have regard to the proper approach to the construction of the treaty when he reached his decision on that case. And if you look at Lord Reid's summary, put shortly, the aim of the interpretation of the treaty is therefore to establish by objective and rational means the common intention which can be ascribed to the parties. And a criticism that I will advance of the Crown's case in due course is that its attempt to its reliance or attempts to marginalise the terms of the 77 Model Treaty Commentary, which promoted the UK's position as to how CMC was in place in later years, relies upon a whole load of materials to which Mauritius was not party. And were entered into after the event. Just to re-emphasise that, I don't need to go through it in great detail because it looks at the particular facts of the convention there in question, which is a US convention, but just at paragraph 58, to anchor my submissions in what was going on at the time at which the 81 treaty was agreed, the contemporary background of a treaty, including the legal position preceding its conclusion, can legitimately be taken into account as part of the context, and Lord Reid cites multiple authorities for support of that. So that is Anson. I was going to turn you in the bundle to the Vienna Convention, but since you've got this open, do you want me just to show you by reference to this, or would you like to mark the bundle up as well?
Yeah, that's fine.
This is fine. Yeah. So clearly, the terms of the Vienna Convention. I was going to turn to you next because it's picked up elsewhere. Treaties should be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty and their context, and in light of its object and purpose. The context includes preamble and annexes. 3. There shall be...
Sorry, just before you get on to the details, given what you've said already, do you have any comment about what's said in paragraph 54, viz. That the approach in the Vienna Convention is an accurate statement of customary international law and therefore binds states even if they're not parties?
My Lord, I wholly endorse that. And there's...
So the fact that Mauritius is not a party...
It's a matter of international law. In fact, there's some case law on that in the Supreme Court. I will dig up the reference to you. My Lord, thank you very much for drawing the point to my attention. There is an authority that makes that clear. I believe it's...
Okay. That's accepted, that's fine.
Indeed, I think actually it's made, we'll come to it in Smallwood, that actually in circumstances where these are principles of customary international law, they apply across the book. There shall be taken into account, together with the context, A, any subsequent agreement between the parties regarding the interpretation of the treaty or the application of its provisions. Now, quite often, in the context of double taxation conventions, you will see, happens all the time, notably recently with Switzerland, we agree protocols to the treaty to amend it subsequently between the parties. There is no protocol in place between Mauritius and the UK which amends the terms of Article 4.3 for these purposes. But I think it's also accepted, and we'll see this in some of the OECD commentary in due course, that by feeding into the commentary that accompanies the model treaty and the exception rules that you'll see, each of the states identifies where it disagrees with particular points in it. That also could be a subsequent agreement if you're all party to it. But of course, our point here is Mauritius wasn't party to some of these subsequent agreements. So I anchor this in the bilateralism of this treaty, the contemporaneous materials that are admissible to it, in accordance with the principles articulated or codified in pursuance to Lord Justice Arnold's point under the Vienna Treaty. Article 32, recourse may be had to supplementary means of interpretation, including the preparatory work of the treaty and the circumstances of its conclusion, in order to confirm the meaning resulting from the application of Article 31, or to determine a meeting when the interpretation, and according to Article 31, leaves the meaning ambiguous or obscure, or leads to a result which is manifestly absurd or unreasonable. If then we could turn to the next Supreme authority, Supreme Court authority, which is Fowler. And Lord Briggs. This is at tab 17 of the bundle. I think it's bundle 2, the hard bundles. Again, my lords, I'm happy to take you through what this case was about. It was about the taxation of profits on the continental seabed for divers, and at the intersection between domestic deemings of employment and treaty deeming. I'm not sure, with respect, that will take us much further for present purposes, but I can happy to explain it to your lordships if you'd like me.
I think, again, there's no need.
Thank you. I'm grateful. What I rely upon this for is the comments of for the approach that's made by my Lord Briggs, and I'm going to deal with this in a little bit of detail, simply because my learned friend relies upon it. And what my learned friend relies upon this for, in his skeleton argument, is set out at paragraph 42 of the skeleton argument. It is said that versions of the OECD commentary entered into after the
Which
date...
paragraph in Lord Briggs?
I'm so sorry.
42 of the skeleton.
Of the skeleton, my lord. I don't think one needs to turn it up. it's my learned friend skeleton. I just want to address a point squarely while we're looking at Fowler.
How about we look at Fowler first?
Okay.
And then you can make your submission on it.
Okay.
Because great, we'll know what Fowler says.
Okay, I'm grateful, my lord.
I think you quote the skeleton quotes paragraph 18 of Lord Briggs.
So the essential point is that what the Supreme Court says is that when it comes to the terms of a treaty, you construe the terms of the treaty not by reference to domestic provisions as to what's meant to be deemed by employment or otherwise in relation to it. And if you look at paragraph 18 of this, what his lordship says is this: the OECD commentaries are updated from time to time so that they may, and do in the present case, post-date a particular double taxation treaty. Nonetheless, they are to be given such persuasive force as aids to interpretation as the cogency of their reasoning deserves. Said in itself, with the greatest respect, we can't demur from it, but there's a little bit of subsequent jurisprudence that explains quite what's meant by this by Lady Justice Falk in due course. So such persuasive force of interpretation to the cogency of the reasoning deserves. Now the importance of this for present purposes is my learned friend's case rests upon subsequent commentaries of the OECD. And the most that you can get out of Fowler is that the OECD commentary is to be given such persuasive force as its cogency of reasoning deserves. The problem here
there's a very similar phraseology used in discussing views expressed by government departments after statutes have been enacted or whatever. And there, I think, Lord Lloyd Jones, who I think at the time was Mr. Justice Lloyd Jones, draws an analogy with academic commentary.
My lords, you've anticipated my point. That's exactly what Lady Justice Falk says. It's the academic commentary point.
Yes.
That's what it means. But just so that we're clear, both in Smallwood, and I shall make this good in due course, the submission was not advanced to the Court of Appeal, or indeed the High Court. The Special Commissioner had got the test wrong for Poem in that case. There was no challenge to the legal test that was applied there. That's the mainstay of our appeal in this case. Nor was the use of the 2000 commentary, which post-dated the agreement of the treaty in 1981, challenged on appeal. And so when Lord Justice Patten makes his comments in relation to the commentary there in question, it's not an issue that you could look at the terms of the 2000 commentary. And of course, my criticism is put in two ways. I'm going to go further in this in a second. The first criticism of the Special Commissioner in Smallwood that I will make is that he went wrong in law by ignoring the particular words of the 77 model commentary that expressly identified the Poem test for Article 4.3 purposes with CMC, or Wooden Holden, as it was then called. He went wrong on that. That's the end of it. But I put it slightly differently as well, that actually, to the extent you can get anything relevant out of later commentaries, they're not permissible as aids to the construction of the terms of a treaty in circumstances where Mauritius was not party to them. And I will make good from the authorities that they're not permissible in a moment, if I may. And just to make good the point that there wasn't any great magic in what Lord Briggs was saying at this particular point in the context of that case, if you turn on to paragraph 30 of his judgment.
So paragraph
30, my lord. Nothing in the treaty requires Articles 7 and 14 to be applied into the fiction deemed world, which may be created by the UK income tax legislation. rather they're to be applied by the real world, unless the effect of Article 342 is a deeming provision, which alters the meaning of it. This much is confirmed by paragraph 811 of the commentary quoted above, and it would be contrary to the requirement to treat the treaty as a bilateral international agreement to do otherwise as required by the dicta in the Anson case. But just dealing there, the commentary there in question, what Lord Briggs was not dealing with in that case was circumstances where he was relying upon the terms of a commentary that was produced after the date of the treaty in question, and to which one of the parties to the bilateral treaty was not party. It wasn't an issue there. So, and with respect, Lord Briggs's summary of the relevance of later commentary as being persuasive is, it doesn't take us any further in this case, given that. The next point to make in relation to that...
You're leaving Fowler, are you?
I'm leaving Fowler in my leave, yes.
I mean, I know that... I think that Mr. Stone relies on paragraph 19. Are you going to come back to that at some stage?
Well, I was going to come... I mean, we can look at it now, my lord. I was actually going to deal with it in the context of Smallwood.
Yes, do.
But in a sense, I've rather foreshadowed my point in relation to it. That this just wasn't an issue before the Court of Appeal in Smallwood.
Yep.
If then we could turn on to the next authority in the bundle, which is Irish Bank. And this was a Court of Appeal decision, again of Lord Justice Patton. And Lord Justice Patton, you've just seen reference in the Fowler case to his judgment in Smallwood. Now here's Lord Justice Patton later in Irish Bank. And it's, if we could just ask, I'd like to show you some passages from there, to show you when he is confronted with a case which concerns a treaty, a commentary which is after the treaty in question, what he thinks about it. Now, you can pick this up without going to the facts in any great detail of it. I might just ask you to turn to paragraph 14 of this judgment. Both the Upper Tribunal and the First Tier Tribunal relied upon the 2018 commentary and their reasons. Relied upon the 2008 commentary and their reasons for deciding to dismiss the taxpayers' appeals. And a significant issue for us is whether the guidance contained in the 2008 OECD commentary is properly to be treated as no more than confirmatory of the scope of the existing Article 7, or whether it did introduce a substantive change in advocating the use of the kata methodology, which can only be given effect by the adoption of the 2010 version of Article 7 of the Model Convention or something very similar. To put the context of this is a little bit fiddly. Essentially, what happened is HMRC disallowed, as part of the taxpayers' calculations, it had an Irish company who was carrying on business in England through a permanent establishment, and HMRC disallowed, as part of the taxpayers' calculation of the profits in that case, the deduction of some of the interest that was shown in the accounts of the UK permanent establishments as an expense of the borrowings made by the branches. And it did so using a particular method. This is just by way of context. Nothing really turns on this. Which was included attributing to the permanent establishment notional, additional capital that was there. And the result of that was to disallow the interest that was in fact paid to third parties. The taxpayers argued that the reference in the UK-Irish treaty then in force, being treated as a distinct and separate enterprise, required an assumption to be made, not only that the permanent establishment was engaged in the same or similar type of business, but also that it should be taken to have traded with the same ratio of debt for these purposes. The FDT dismissed the argument of taxpayer and relied upon the terms of the 2008 commentary, which we'll look at in a moment to do so. The Upper Tribunal dismissed the argument and again relied upon it, and that's what's being recited there. Then what happens is Lord Justice Patten sets out the proper approach to the construction of the OECD commentary. And then if you turn on to deal with that,
so he quotes the usual passage from Commerzbank.
he does, my lord. Yeah, exactly. But if one looks at paragraph 23, the 22 sets out the Upper Tribunal's view. 23, Mr. Baker submitted that Article 31 of the Vienna Convention should not be treated as an exhaustive and immutable code, and I think that may be correct. As with any other set of legal principles, the norms of international law are capable of development and change. What the Upper Tribunal said in paragraph 30 of its decision is an established norm of international law. By contrast with that, the appellants, the taxpayers, have been unable to identify any established principle of international law which recognises the unilateral practice of a contracting state as an aid to the construction of a treaty. And in my submission, that is what is going on here in our case. If you just go through this to paragraph 25, there's a summary that's given by Lord Justice Patten of what happens to the OECD treaty there in question. The middle paragraph. In summary, therefore, the language of Article 7 of the Model Convention remained essentially unchanged between 1963 and 2010, and, as the evidence about the PW formula illustrates, was in use in double taxation treaties as far back as the 1950s. This is consistent with the findings of the FT. The UK practice since at least the 50s was that it was necessary to determine the amount of free capital. He then recites the terms of the 63 commentary in that case in some detail. And then a summary is produced at paragraph 27. As mentioned earlier, there are no changes of substance in the OECD model conventions and commentaries published in 1977 and 1994. And of course, although these post-date the 1976 convention, their significance is to confirm that the wording of Article 7.2 continued essentially unchanged throughout this period. In 2008, however, the OECD published a further edition of its model convention in which Article 7 continued in the same form as the 1963 edition. The commentary was, as the Upper Tribunal put it, significantly different. And then he explains the difference in paragraph 28. I don't think one needs to look at what the difference is for these purposes. I think if you turn on then, please, my lords, to paragraph 31. Although paragraphs 43 to 47 of the 2008 commentary are new, it's clear from paragraph 7 of the commentary that they were considered appropriate for inclusion by the OECD because they were not in conflict with the earlier versions of the commentary. Now, on my learned friend's case, now bearing in mind we're dealing with two parties to the OECD, Ireland and England in this case, on my learned friend's case, he says the 2000 commentary and subsequents to the earlier one is in conflict. He must say that to the 77 treaty. So we've got a conflict in our one, and I'll make that good in due course. And then Lord Justice Patten carries on. And the third sentence, but to succeed in this appeal, Mr. Baker's, that's the Taxpayers' Council, clients must establish that any attribution of capital which results in the disallowance of interest paid by the permanent establishment on the money it's borrowed is simply impermissible under Article 8.2 of the Convention. This is ultimately a question of construction, but HMRC placed considerable reliance on the 2008 commentary as confirmation that Article 7.2 has always permitted a considerable degree of flexibility in the methods for the attribution of profits to a BE, and that these can include various forms of capital attribution. On that basis, the 2008 commentary, although new, would be admissible as an aid to the construction of Article 8.2 of the 76 Convention, which, as I have explained, adopted the wording of Article 17. It would only be inadmissible if the new material made substantive changes which are inconsistent with the commentaries in existence at the time of the 76 Convention.
And the conclusion is that that's not the case.
Yeah, well, do you mean, sorry, my Lord, do you mean Lord Justice Patton's conclusion?
Yeah, he goes on and says it's not inadmissible for that reason.
Yeah, exactly.
On the contrary, he says it's persuasive, although he would have reached the same conclusion anyway.
But you are dealing with circumstances where both of the parties there in question were parties to the OECD treaty.
Yeah, but that's a point you made a number of times, and it may be a good one, but I don't see what this has got to do with it. I mean, this is concerned with the circumstances in which you can look at a subsequent commentary where there's no issue about parties. And this decision says, yes, you can look at the subsequent commentary. I mean, it's obviously a decision based on the circumstances in that case. As I say, this doesn't mean to say your point is a wrong one. I just don't see what this authority's got to do with it.
Well, my Lord, if we
Really, that last sentence of 31, you're referring to this not for the decision in the Irish Bank case, but to say that what you say the Crown's case is here on this point is inadmissible because they are looking to rely upon a later commentary which is inconsistent with the earlier one.
And then look at what Lord Justice Singh says in due course, and Lady Justice Rose agrees with both judgments in relation to it.
Right, so where do we go in Lord Justice?
That's paragraph 59, my Lord. In this case, we are concerned with the interpretation of an international treaty. As Lord Justice Patton has said in his judgment, subsequent state practice can sometimes be a relevant aid to interpretation in accordance with the Vienna Convention. However, since there is more than one party to a treaty, what is required is evidence of practice on the part of both parties to the treaty. As the Upper Tribunal rightly said, unilateral practice of one party cannot alter the meaning of a treaty. And Lady Justice Rose agrees with both of them. So then if we could turn, I'm going to turn to Smallwood in a bit. I would like to show you, before we look at Smallwood, the terms of the 77 Model Convention and the terms of the commentary that was published at the time of which it was issued.
Have we got that? Is that the supplementary?
In fact, my Lord, that is actually in the bundle you've got in front of you.
All right.
There are many iterations of the commentary in the bundle, and obviously the one upon which we rely, and which we say the Special Commissioners in Smallwood went wrong and set this all off on a wrong tangent, is that which is contained behind tab 24 of the bundle. And if you just start on page 642, Model Double Taxation Convention on Income and Capital.
Sorry, I missed you. What paragraph?
Sorry, it's the page actually, my Lord. Page 642 this is the Model Convention.
Yeah.
So this is the one that was in place prior to the negotiation of our treaty in 1981. And if one just looks at Article 4 of the Model Convention, it's in materially the same terms as the terms of Article 4.3 of the treaty. Sorry, I'm making the obvious point, but just to take you through it in a logical sequence, my Lord. You look at Article 4.3, where by reason of the provisions of paragraph 1, a person other than an individual is a resident of both contracting states, then it shall be deemed to be a resident of the state in which its place of effective management is situated. Now behind that, you have the commentary on it. And just, as it were, to show you how these commentaries work, page 645, this is actually dealing with the general definitions of it, sets out some of the definitions to do with the earlier bits of the model treaty. And then if you turn onwards, just turn to 647. You'll see the start of this. We're going to see a lot more of these in due course. Particular members of the OECD register restrictions in circumstances where they don't agree with the commentary or where they reserve the right to behave in different ways in relation to it. And then if we turn to 648, you see the start of the commentary with which we rely, as we say this is the most authoritative statement of what was meant by the terms of this treaty, for reasons I'll expand upon in due course. It explains the preliminary remarks in relation to it. And then it talks about the provisions. On page 649, paragraph 1 provides a definition of the expression resident of a contracting state for the purposes of the convention. Definition refers to the concept of residence adopted in the domestic states. Paragraph 2, that's concerned with individuals, the same as our Mauritian treaty, but there is a sentence in it that's quite useful. As far as possible, the preference criterion, so to solve the conflict, special rules must be established which give attachment to one state, a preference over the attachment to the other state. As far as possible, the preference criterion must be of such a nature that there can be no question but that the person concerned will satisfy it in one state only, and at the same time it must reflect such an attachment that it is felt to be natural. The right to tax devolves upon that particular state. So, as far as possible, that's what the preference criterion there is intended to do. Our preference criterion, our tiebreaker, is that in paragraph 3. And if I could ask the court, please, to turn to page 651, paragraph 21. Paragraph 3. This paragraph concerns companies and other bodies of persons, irrespective of whether or not they're legal persons. It may be rare in practice for a company to be resident to tax in more than one state, but it is of course possible if, for example, one state attaches importance to the registration and the other state to the place of effective management. So in the case of companies, etc., also special rules as to preference must be established. It wouldn't be an adequate solution to attach importance to a purely formal criterion like registration. Therefore, paragraph 3 attaches importance to where the place where the company is actually managed. 3. The formulation of the preference criterion in the case of persons other than individuals was considered in particular in connection with the taxation of income from shipping, inland waterways transport and air transport. A number of conventions for the avoidance of double taxation on such income accord the taxing power to the state in which the place of management of the enterprise is situated. Other conventions attach importance to its place of effective management, others again to the fiscal domicile of the operator. Concerning conventions concluded by the United Kingdom, which provide that a company shall be regarded as resident in the state in which its business is managed and controlled, it has been made clear on the United Kingdom side that this expression means the effective management of the enterprise.
Yes, and you need then to read paragraph 24. As a result of these considerations, the place of effective management has been adopted as the preference criteria. So, at the moment, it seems to me what this is doing is explaining why the criterion place of effective management has been adopted instead of, e.g., fiscal domicile.
That's what 24 says on the face of it, but with respect, my lords, and I believe this comes out of the authorities as well in due course, I think it is also going further than that and saying the UK's position at the time at which this commentary was issued was that it meant the same as central management and control. That's what
let's assume you're right about that. What would be the significance of that in your submission?
Well, it's the end of the case.
Why?
Because if I'm right, the only thing that you can take into account...
Sorry, I'm a little puzzled by that. Because let's assume you're absolutely right, that that was the UK position at the time, and that this is what is reflected here. Is it your submission that this is an acceptance by the OECD of the UK position? Because if that is your submission, I'm struggling to get that out of the words.
Well, my lord, we're going to see in due course that those words are removed in due course. And it is said by my learned friend, and it was said by the special commissioners, that there should be some meaning attached to the fact that they were removed in relation to it, because they changed their views as to how to construe it. It's one of the points that's made in the statement of practice in the bundle that we'll give you after lunch in relation to it. The submission that I make in relation to this is, if the contemporaneous evidence, this is the best contemporaneous evidence we have of the United Kingdom's view of what this treaty is meant to establish by place of effective.
No. This is looking at the United Kingdom's prior position. So what it's saying is the United Kingdom's prior position was as follows. And then that a choice is made as to what is the preference criterion that is adopted. Now, at the moment, I'm still not quite clear what your answer is to the question I was asking, which is whether it is your submission that this is to be read as accepting the United Kingdom's position.
I believe it is, my lord.
As to the meaning of
Yeah.
place of effective management, as opposed to the UK position being one of the reasons why that criterion was adopted. And to my mind, those are not the same thing.
My lord, I will make this bet. I will take you to some other materials to make this good. Irrespective of whether the OECD are accepting it as being the position for the purposes of its treaty, what it is recording, in very plain terms, is that the UK's public view was that it meant the same thing.
Can I just understand that? The hypothesis is that the United Kingdom has been entering into treaties in which residence is to be judged by where business is managed and controlled.
Yes, my lord.
Using those words.
Yeah, and that's what their previous Mauritian one did, as we'll see in Smallwood.
Yeah. The United Kingdom has said that when we use the words managed and controlled, we have in mind effective management.
Exactly.
But you're some remove from what the phrase place of effective management might mean when it's incorporated in the new model convention.
In the Mauritian treaty? Or in the new treaty?
The OECD is adopting this new phrase, place of effective management. I suppose I'm echoing my lord. Why does one take it that in adopting the place of effective management in the model treaty, that is to be equated with what the United Kingdom understands business is managed and controlled to mean?
Well, if one turns over the page to look, for example, at the restrictions on the article, it would be a peculiar thing in identifying that the UK's position was to equate the two tests as being the same. And then for a series of restrictions to be made, which apply a different test in relation to it.
When you say restrictions, you mean the reservations?
Reservations, sorry.
Yeah.
Yes, so those countries are reserving the right to apply a different test.
Yeah.
That is to say, not the POEM test.
Yes, my lord. Yeah.
By contrast, we see in paragraph 25, New Zealand enters a view as to the interpretation of the POEM test. So it's agreeing that that should be the test and putting on record what it thinks it means.
Yeah. But my lord, in a sense, whether or not the most that you can get out of the terms of this treaty is that this is why they selected it or otherwise, this is an unequivocal statement of what the United Kingdom's practice was, which was to align the two matters at the time.
Okay, well, I think we've got that submission. Thank you.
If we could turn on then to Wood and Holden, my lord.
Well, would it be convenient to, while we're on the conventions, to track through the later ones and see how
I
they
think
differ?
that would help me. So.
Yep, we can definitely do that, my lord, yes, of course. So if one turns to the 2000 convention, we're going to see this discussed a bit in...
Right, do we get anything out of 1992?
Oh, if you turn on to 1992 to start with on page
653. Just
653.
tab 25.
Paragraph 23.
So at this stage...
They've taken out that last sentence, my lord.
I mean, I don't know what significance one attaches to that. I mean, the sentence said that the United Kingdom had been concluding conventions using its businesses managed and controlled. Well, I don't suppose it was concluding those conventions anymore.
But it was concluding those meaning managed and controlled. And on the United Kingdom section, that this expression means the effective management of the enterprise.
Yes,
But was it still concluding conventions of that kind in 1992?
But if it's agreeing to the terms of a treaty, I mean, what I'm worried about is we're concerned obviously with the terms of bilateral treaties between Mauritius and the UK. But in terms of the United Kingdom statement of practice, as at the 1981, they were saying that the place of effective management meant managed and controlled.
I mean, I quite see the significance you say you can get from the last sentence of paragraph 23 of the 1977 version. I'm not quite sure what significance, if any, you can get from the fact that it's then left out.
No, I don't rely on the latest treaty.
No, I know.
They're not. I say we shouldn't take any notice of them.
But are you disputing the factual question? Because the hypothesis my lord was exploring with you is that the reason for the omission of that sentence is that post-1977, the United Kingdom had not concluded new treaties providing that a company should be regarded as a resident of the state in which its business was managed and controlled.
Well,
And therefore, to have reiterated that statement would have been redundant because the United Kingdom wasn't doing it anymore.
my lord, I can't speculate as to why what was in the minds of the United Kingdom or the OECD when they removed that sentence.
There's a factual question.
Yeah. Did
So
they have
are
treaties?
you able to point to any treaty concluded post-1977 by the UK in
Use the old
which
language.
company is regarded as a resident in the state in which its business is management and controlled?
My lord, I'm not at this
Right.
moment. I'd be surprised if there was one because obviously
Because they've
post-
used the
exactly,
new
because
word.
after 77 we were using
Yes.
this one.
Yeah.
But I would be nervous to make a positive submission to the effect we didn't do one, given that there are however many hundreds of them. But I think it's highly unlikely because post 77, for the reasons that have been identified, the model treaty was incorporating place of effective management of the state. In fact, this is all being rewritten again. The model treaty doesn't read in these terms now. The model treaty now imposes a kind of particular type of mutual agreement procedure as the first tiebreaker between the states. But in answer to my Lord Justice Arnold's question, can I point to a treaty that was agreed in materially those terms post-77? I can't at this moment.
Thank you. So does that take us to the 2000 one?
2000, so by 1992 it's gone. By 2000, and this is the one that's referred to by Special Commissioners in Smallwood, it's written in slightly different terms. As it happens, we submit that properly read, there's nothing in that that's inconsistent with our construction of the CMC test being the appropriate means of identifying the place of effective management. However, we also say, I really don't understand what juridical basis one can have as using a commentary on a multilateral model treaty to which Mauritius was not party, as determining the meaning of the bilateral treaty.
But sorry, just to get the basics straight, what differs this time, as I understand it, is the extra wording in paragraph 24.
Yes.
The 21 to 23 are the same.
I think that's right, my lord. Yes.
Yeah.
If you yeah.
And you make two submissions about the new bits of paragraph 21, or you say, firstly, it's irrelevant because Mauritius is not a party, and secondly, you say it doesn't contradict your construction anyway.
No, exactly, my lord.
Thank you.
So it's 24 that matters.
Yeah.
Sorry, my lord.
It would be paragraph 24 that would be significant if it's significant at all.
Yeah, exactly. There are then, for the sake of good order, the subsequent commentaries in there as well, and my learned friend will probably turn you some of those pages. I'm not sure whether it's going to assist us further at this stage.
Does paragraph 24 travel on through those? Yeah.
I think my learned friend is going to take you to some
bigger.
passages in the earlier bits of the commentary, but perhaps I'll deal with those in replying.
Good.
If we could turn to Wood and Holden. At tab 10, page 135. Wood and Holden, I know that my Lord Justice Newey is very familiar with this from his development securities case, but if I may, I'll take you through it in some detail because I think it is it's obviously an important component of our case, and also where I say that the special commissioners in Smallwood went wrong. If you perhaps turn to start, just to get the facts are quite neatly summarised in the judgment of Mr. Justice Park, which starts on page 171. I should just state the court reports that we've used for Wood and Holden and Smallwood are not the most authoritative version. We've used a tax report, which I hope is acceptable. We can give you the other ones if that's helpful, simply because it has all of the decisions the whole way up. I hope that's acceptable. But it's only for those two. So if one turns to page 171, Mr. Justice Park. And on 172, you see in paragraphs 3 to 4, if I could ask you to read it, just a summary of how the tax avoidance scheme there was identified to work. that's how the scheme operated. The summary of the facts, I wasn't proposing to take you in great detail through the Mr. Justice Parks summary, but if in due course one needs to look at the summary of the facts, they're very conveniently set out between paragraph 6 and 17 of his judgment. Now, just to make a few observations in passing as we go through this authority. The first point to make is this. If one turns back please to page 163 of the judgment. There's a summary of the facts as found by the special commissioners. And I don't think you need to read these in detail now, but just in due course, paragraphs 132 and 136 are going to be picked up by the judgments of the senior courts.
Sorry, paragraphs 132
and 133, forgive me, about the evidence or otherwise that was before the decision makers there in question. In due course, it's the foreshadow of the case that's advanced before you in development securities laws about what the quality of the decision making was. Paragraph 141, you see a strong finding made there by the FTT. However, it does not appear that any real consideration was given by the Dutch trust company at all. And that's picked up in due course as well. Mr. Talon, who appeared for the taxpayer, paragraph 146 raises the question of where the place of effective management was suited. That's because of the terms of the issue there in question. We accept Mr. Brennan's submission at paragraph 103 that in the present context, there's no difference between central management and control and the place of effective management. In our judgment, the place of effective management must be the place where effective management decisions are taken. HMRC's case, advanced before the special commissioners, in Wood and Holden, significant amount of time after the negotiation, the treaty at that point in time, is that it's the same test.
In the present context.
In the present context, right. Then turn on to Mr. Justice Park. And it's a decision that's made by Mr. Justice Park. It's also, I will submit, a strong submission because it's an Edwards and Bairstow interference with it. It was a strong overturning of the terms of the special commissioners in relation to it. And he sets out in paragraph 41 his criticisms of the judgment of the decision of the special commissioners. And he goes through the decision of the special commissioners in some detail, criticising it. There's an interesting point that emerges, just if you happen to be reading it, it's not relevant to the present case, but often this case is cited not just for authority as to what the test is for the identification of corporate residents, but also we'll see Mr. Justice Park's observations regarding the burden of proof in tax cases, and you'll see that's picked up by Lord Justice Chadwick. It's not relevant to the present case, but it's an important authority. It's regularly cited for that proposition as well. Now, the key thing is, if one turns on through the decisions of Mr. Justice Park, the first point that I make in relation to it is, if you turn to page 197 of it, when it comes to the application of the test at this point that he's examining, central management and control, he's focused upon the relevant decisions of the company. and he's at pains to point that out. What I must examine are the decisions that are relevant. And in paragraph 68, the decisions which matter are the decision in July 1996 that Eulalia should purchase the shares holding, and the decision in October 1996 that Eulalia should sell the holding. So everybody knows this is being done pursuant to the terms of a tax avoidance scheme. But in testing what the place of central management and control is, what Mr. Justice Park does, is focusing upon the decisions that fell to the company whose residence was being tested to make.
Yeah. Can I see if I've understood the context of that observation? Am I right in understanding that the crux of it is that it was HMRC's own case, as you pointed out, that the relevant test was the CMC test?
Yes, my lord.
Mr. Justice Park held, well, the Special Commissioner's reasoning was inconsistent with that test.
That's right, my lord.
Right. But is it your case that that was thereby endorsing the test?
Well, we're going to see that now, my lord, in the next bit of Mr. Justice Park's reasoning. We're coming to place of effective management.
Because at the moment, I don't think I've seen that there was any disagreement between the parties on that score. I mean,
there wasn't.
Right. So it was common ground that the test was the CMC test.
Well in that case, they were concerned with CMC in the first instance.
And the issue was, had the Special Commissioners applied it correctly?
That's right.
I mean, there were two potential questions, weren't there? There was CMC and there was potentially place of effective management separately.
Yeah. If
But
you
at
got
this
into
stage,
that,
we
but you
didn't.
didn't need to get into poem, as we'll find out in due course, because it was resolved on the first point.
Yes.
Nevertheless, Mr. Justice Park does make, in the context of the poem test there in question, a number of observations in relation to it, and they're picked up by Lord Justice Chadwick in due course.
Yes.
The point I was just referring you to is an element of the judgment that applies in the context of the CMC analysis. But, as it were, the reason I drew your attention to that is that the eye of the judge is very much, as it was indeed in development securities, upon the identification of which are the actual decisions which fell to the relevant bodies. And the criticism that I will advance in relation to my learned friend's case and the FTT in this case's decision, insofar as it's possible to identify a test that's being made, and I submit there isn't, is that it doesn't have the forensic accuracy of identifying the decisions that fell to the trustees, qua-trustees, to make.
Yeah.
And that reasoning, that approach, I will submit, applies equally to CMC and poem.
And just to be clear, the CMC test is prior because that's about residence.
That's right, my lord. Yeah. Because you didn't get into the terms of the secondary point if they'd already succeeded on the first point that it was resident. Now, if one starts, please, at page 273 of the judgment of Mr. Justice Park, page 199 to 201, this makes good the point I've just been discussing with my Lord Justice Arnold. I wonder if I might just invite you to read that.
So 73 to
73 to 81, if I may.
Yeah, just before we get into that, so 72, he says, common or residence decision of the commissioners can't stand.
Yes, my lord.
And so that was dispositive.
Yes, it was, my lord.
And 73 and following are therefore obiter, is that right?
I accept that, my lord. Yeah. I mean, the Upper Tribunal in our case makes the observation in its judgment that although they're obiter, they are highly persuasive.
And what is your submission about these paragraphs? Because at the moment, I'm struggling to understand how we are assisted by them in circumstances where, as you helpfully pointed out earlier, the special commissioners applied the same test. I mean, it was the revenue submission that the test was the same, and that the special commissioners accepted that. And once Mr. Justice Park had said they were wrong on CMC, it would seem necessarily to follow that they would also be wrong on poem.
Well, if it was necessary that they were also wrong on poem, then that aligns the two tests. And that's my point.
Well,
so here this
in circumstances where they'd accepted the revenue submission that the tests were the same.
Well, in a sense, that's my point, my lord. The revenue's position was that that the test of poem in the context of the Dutch treaty there in question, which is in the same language as our
But how does that help us in
one.
a case where the revenue's position is that they're not the same?
Well, it helps me in this because the taxpayer in this case was arguing that they were not the same test. That's what, and it's rejected. Mr. Brennan repeated before me his successful submission. He said that if the central management and control of Eulalia was in the UK, and so also its place of effective management must have been situated in the UK, and Mr. Goldberg submitted otherwise. He said the place of effective management of Eulalia was in Amsterdam, and that was so even if, on the common law test of residence, had the effect that, contrary to his submission, the company was resident in the UK.
Just to understand the result, Mr. Justice Park says, supposing that CMC is in the UK, nevertheless poem isn't.
Yeah.
So you're not quite, I mean, it's obviously not applying quite the same test.
Well, I think that comes back to almost the burden of proof point, because what that Mr. Justice Park is making in relation to that. If you look at paragraph 77, Article 4.3 requires there to be identified a place of effective management. And it has to be a place situated in one of the two states. So far as common law residence is concerned, it might be enough for the revenue to say that the central management and control of Eulalia was carried on in the UK without needing to be more precise and to identify specific premises. On that basis, the revenue might be able successfully to argue that Eulalia was resident in the tax jurisdiction of the UK, and they do not need to go into any further. 78. That, however, will not do when it comes to applying the detailed wording of Article 4.3 in the same terms as R1. What was the place situated in the UK which was Eulalia's place of effective management? The commissioners did not attempt to answer the question. And I think in that, and then if you go on to paragraph 80, in my judgment, it cannot be enough for the revenue simply to say that they're not sure what the precise place of effective management of Eulalia was, but whatever it was situated somewhere in the UK. Therefore, if I'm wrong on that, on the common law test of residence, I nevertheless consider the effect of section 249, that's the equivalent to our implementing provisions that I took you to earlier, 788, read with the tiebreaker in Article 4.3 of the UK Netherlands double taxation, is that by statute, Eulalia was resident in the Netherlands.
It becomes, not this case, but it becomes harder in the modern times to think that necessarily there will be a place if everyone's working online and communicating digitally and virtually.
My lord, that actually, it's a point.
But I don't want to head off and
no, it's absolutely hot potato in tax terms.
I wonder, just looking at the words here, whether Article 4.3 does require a particular place, because you then get into, as Justice Park does, is it his house, is it his office, and there may be none of these, but it may be collectively still taking place in the UK.
Yeah, it may be that these are events, in our particular case, these are events a quarter of a century ago.
Yeah.
So the world was rather different.
It was different, but I'm just.
I mean, you might think it's good enough to say the place of effective management is the United Kingdom, rather than
Quite.
any particular office in any particular town.
It opens up
I
all sorts of
think
difficulties.
I would struggle to try and challenge that. But the point that I think is important from this is that so far as Mr. Justice Park's concern is subject to that point about which building you're in, he thinks the test is essentially the same. When you ask the question, who is managing this, it's the same answer.
And where is the best passage for showing that he takes the test to be the same?
Well, I think that you may get that more from Lord Justice Chadwick.
And I thought your submission a moment ago in answer to my question was the opposite, because I was precisely putting to you that it was the Crown's position that the test was the same. Commissioners had accepted that, and I was exploring with you the consequences of that, and you said, well, but he accepted the submission of the taxpayers that the test was not the same.
Well, but I think he accepted this. I don't think there's a challenge to the test in the case of the taxpayers. I think that what they're saying is on the evidence that was there, and that's why you get the comments about the burden of proof that becomes so important to taxpayers in due course.
Is this a burden of proof? I suppose this is a sort of burden of proof point, but it's a point about the specificity that required by Article 4.3.
That may not be a burden of proof point, my lord.
No.
But I mean, it may be a mechanism by which of testing it. It's the same mechanism you might apply to trying to identify what the test is against me in this case. Who was it? The settler, their tax advisors, their bankers, and that's why we submit that the test of CMC is capable of operation in these circumstances, but otherwise it's the Wild West in terms of how you identify on any principle basis how to construe the terms of 4.3.
I'm sorry I'm being very slow here, but can we come back to the question that we were just debating? In 75, as you pointed out, he recites Mr. Goldberg's submission that was otherwise, because Brennan submitted, it was the same test. Mr. Goldberg submitted otherwise. And then, as you pointed out, the judge says, on that issue too, I agree with Mr. Goldberg. So he is agreeing with Mr. Goldberg that it's a different test. He's disagreeing with Mr. Brennan's submission that it's the same.
My lord, let me just get the reference to you as to what was said below in relation to it. But as I read that, he is making the point that it's on the facts, essentially. It's on the evidence. The place. That's why he talks about the place.
But
if you look,
I'm sorry. I'm as I say, I'm sorry if I'm being very dense here. But the whole point about Mr. Brennan's case was that if the CMC was in the UK, then it followed that the poem was in the UK. Whereas Mr. Goldberg submitted otherwise, and therefore it's inherent in taxpayer's position that it's not the same test.
But what the judge goes on to show, my lord, is that when it comes to the question of what the disposition is of whatever the test is in relation to it, the taxpayer has reached a point where it's put forward a positive case as to where it was being effectively managed, and HMRC didn't have any candidate alternative view, and at that point the burden had shifted, and that's what's going on, I think, in 80 and 81. Against that background, I repeat, this time in the context of section 249 and 843, something which I've already said in the context of common law residence, surely the point has been reached at which the appellants in this case can say that they've shown a great many things from which it would appear that, although not much effective management was required for what Eulalia did, the place where the effective management was carried out was at AA, as the corporate trustees, corporate service providers' offices in Amsterdam, and the evidential burden must shift to the revenue to produce some evidence that the place of effective management was not there at all.
Well, that's dealing with the facts rather than legal principle.
Yeah. What is the legal test that you submit that he's applying?
I think that he is applying the CMC test, my lord, with the possible clarification that my Lord Justice Arnold says, putting the pressure on the word "the place." But in a sense, Lord Justice Chadwick deals with this as well, my lord. So maybe we could turn to that and come back to it.
All right.
I apologise. I will try and polish that for you.
Well, I mean, as you rightly say, it's probably the decision of this court that matters anyway.
It is. You're the, in a sense, it's the Court of Appeal that matters in relation to this.
Yeah. So
But-
Shall we turn to that then?
Yes, my lord. And if you turn to paragraph 22,
Yeah.
If you turn to paragraph 22, it's important to keep in mind that an appeal from a decision of the Special Commissioners to the High Court is limited to cases in which the appellant is dissatisfied in point of law with that decision. And it goes on to set out familiar jurisprudence in relation to it. Paragraph 23, paragraph 24, reference to De Beers. And then at paragraph 27, we see the summary of the common law position in relation to it. In my view, the judge was correct in his analysis of the law, in seeking to determine where central management and control of a company incorporated outside the UK lies. It is essential to recognise the distinction between cases where management and control of the company is exercised through its own constitutional organs, the board of directors or the general meeting, and cases where the functions of those constitutional organs are usurped, in the sense that management and control is exercised independently of or without regard to those constitutional organs. And in cases which fall within the former class, it is essential to recognise the distinction, in concept at least, between the role of an outsider in proposing, advising and influencing decisions which the constitutional organs take in fulfilling their functions, and the role of an outsider who dictates the decisions which are to be taken. In that context, an outsider is a person who is not himself a participant in the formal process, a board meeting or general meeting, through which the relevant constitutional organ fulfills its function. Then the judge goes through, or Justice Chadwick goes through the judge's reasoning. And on page 223, in the middle of that by C, in addressing whether ABN AMRO had taken effective decisions, the judge pointed out at paragraph 68 of his judgment the two decisions which matter are the decision in July 1996 that Eulalia should purchase the 49% holding holdings, and the decision in October 1996 that Eulalia should sell the holdings. So he focuses on those two decisions as well.
So all of this is discussing
Corporate
Justice
residence.
Park's decision on common law residence.
Exactly. But again, the focus on those decisions. And then at paragraph 37, sets out his summary of the disposition there of the judge. 38, we've sidelined this, Lord Justice Chadwick identifies the terms of HMRC's appeal to the Court of Appeal. It said that special commissioners had directed themselves correctly in point of law, and that on an appeal under 56A there was no power to set aside the decision on the facts. Paragraph 40, in my view, the judge was correct to hold that the only
Hang on, the second half of paragraph 39 between D and E. The question for this court is whether the judge was correct to hold that the conclusion which the special commissioners had reached on the facts which they had found was a conclusion which was not open to them, which was found not open to them by law.
Yes, my lord.
So that's what they're saying the case was about.
Yes, my lord.
Yes. So it was the Edwards-Bairstow
Yeah,
test.
exactly.
Yeah.
Yeah. So then paragraph 40, in my view, the judge was correct to hold that the only conclusion open to the special commissioners on the facts they found was that Eulalia was resident in the Netherlands. And then the judge goes on at paragraph 42 to identify what he sees as being the legal flaw in the special commissioner's case in the context of the corporate residence question. The legal flaw in the Special Commissioner's approach, as it seems to me, was to treat the decision that was made by ABN AMRO as managing director of Eulalia as if it were not an effective decision by a constitutional organ exercising management and control. And then paragraph 43, this is a point that's picked up in Development Securities. Further flaw in the Special Commissioner's approach was to treat the decisions which were made by ABN AMRO as not effective decisions because they were reached without proper information or consideration.
But again, this is all still about
Corporate residence, my lord. Yeah. We're not on to place of effective management yet. For those reasons, I would uphold the judge's decision to reverse the Special Commissioner's finding as to the residence of Eulalia on the basis of the Central Management and Control Test. That makes it unnecessary for me to consider what the position would have been if the effective place of management test posed by the double convention taxation is relevant. I've already indicated that I find it very difficult to see how in the circumstances.
So when he says he's already indicated that,
Yeah,
where?
Sorry, my lord, I should have taken you that and we're way past it. It's paragraph 6.
6.
Page 203. I'm good.
But he doesn't explain why.
No.
He says it's not clear to him that the Article 4.3 test differs in substance from divisions, and if they're not in substance the same, it's very difficult to see how, in the circumstances, especially they could lead to different answers. Well, fine, but why?
Well, my lord, that's why we're here. But
Just
yes, my lord.
I'm not taking out of your term. Paragraph 27, page 218 and 219. That's the paragraph where the words usurped and dictates
Yes, my lord.
come in. And looking at the beginning of that paragraph, 27, the first sentence, in my view, the judge was correct in his analysis of the law for a second sentence in seeking to determine where that central management and control. So usurped and dictates in that paragraph are relevant to central management and control,
Exactly, my lord.
not necessarily place of effective management.
Well, we submit as a principled basis that the test is the same, and that therefore, in circumstances where the properly constituted organ or body of an entity or trustees in these circumstances has their role usurped or a position dictated to them or instructed, to use the language of Development Securities, that will displace the place of effective management from being that in which those persons are resident.
And it may well do, but it doesn't mean that's the only criteria that could displace such a finding.
Well, on the basis, my test is that in circumstances where at the time of the 1981 treaty, my submission is that the UK's position was it was the same test, and we've been negotiating treaties on that basis previously, and that was what
I'm
was
with you. I
known
can
to
see
those
why
parties.
I'm
It's
following.
the same test.
Yeah.
And I have to accept that the categories of circumstance in which you may find dictation or instruction, it's a common law test. There may be a set of circumstances where there's some other thing which will, as it were, displace the properly constituted body of it. But I think, as we'll see in a moment, Development Securities, it's not necessarily a closed book, but these are the ordinary circumstances in which you will find it being somewhere else.
Good.
So, to make sure, I believe, my lord, I hope I've made this clear. My submission is, in circumstances where we say the test was the same in 1981, the reason that we caveat our test as to the displacement in these circumstances by reference to the CMC test is that we say that in the context of this case, there wasn't any finding of usurpation or otherwise. In fact, the opposite of that, the trustees were found to have made the decisions. And the difficulty that I advance in relation to my learned friend's case is that we do not have a principled articulation of what the test is meant to be. Just so that you can see, my lords, the most recent authority on this, senior authority on it, Development Securities, which is in your second volume of your...
We've got it all in one volume.
Oh, good. It's tab 20.
Thank you. No.
No.
19.
My lord, if I could just ask you to read you don't need to read the whole thing, we'll look at that in a moment, but if you could just look at the headnote to get a good summary of the facts. I hesitate. I'm sorry, my lord.
Don't worry, I don't remember the detail.
Again, another tax arrangement.
Yes.
My lords, this is not a case. This is not a case that's concerned with the place of effective management, and certainly not in the context of the Mauritian Treaty. I take you to this as a statement of high authority of the relevant principles for the approach to the application of the CMC test, which I say is the right test in these circumstances. And if one turns to paragraph 14, Lord Justice Arnold, Lord Justice Newey in his judgment, codifies or provides a list of the principles to be drawn from those authorities.
Yeah, but as you say, that's all about common law residence.
It's about common law residence, my lord, but in my submission, in circumstances where one is called upon as a court to identify a test for place of effective management, we say that the UK's practice for 100 years prior to the negotiation of this treaty was to equate them as the same test.
Yeah, but you don't get that out of paragraph 14.
I did not get it out of that, my lord, but I have to show you it because
it's an illustration of what it would be if it.
Or what it would be if that is
yeah,
the
yeah,
test,
yeah.
and of the familiarity that the English courts have with using this test. It's predictable, it's objective, it's capable of measurement by taxpayers and HMRC alike, so that it is capable of uniform application. But there is no candidate alternative test for it. Good. I I don't think we need to turn to it, but I think my Lord Justice Newey will recall that the Upper Tribunal decision of this, of course, it was HMRC's case before the Upper Tribunal, that central management and control and POEM meant the same thing.
I'm afraid I don't remember that at all, actually.
Well, I don't think, it doesn't get, it's not relevant to today, but it is, my point is that it has been repeatedly been the case of HMRC, even after the amendment of the terms of the OECD model commentary on these terms, that those tests were aligned. You saw it in Wilden Holden, you saw it in development securities where it's relevant. But this is a test capable of universal application. And then, just so that you've seen Lord Justice Newey's disposal of it, I think one of the critical sentences is that on paragraph 81, page 538. I hesitate to think. What matters is that the FTT made findings to the effect that the directors, in fact, proceeded on the basis of what they perceived as an instruction, rather than just an authorization or ratification. And then in paragraph 84, there's a wider criticism made. And the important point there is that, as I understand the effect of my Lord's judgment in relation to it, the boundary line is drawn between an instruction that is given by a parent to a subsidiary or by some other person, be it a shadow director or a trustee de censeur of a set of trustees, or usurpation, and the mere taking of advice, and the following of that advice, which is what the findings of fact demonstrate in these circumstances. And proposals. In this case, in development securities, as my Lord vividly illustrates in the course of his judgment, the subsidiary, and it's not criticised from a corporate law perspective for doing so, follows the direct instruction of its parent. And one of the difficulties that I'll come on to in relation to the Crown's position as to how you construe the terms of place of effective management is that it doesn't put that dividing line in place. With, the Upper Tribunal said that I spoke with some hyperbole when I made this comment before it. But it is very hard for advisors in the City of London who earn their daily bread from advising on corporate reconstructions going on outside the UK and otherwise to ascertain where on HMRC's position that dividing line is drawn. When it comes to the application of the CMC test, there's a very mature body of case law that makes it perfectly plain where that dividing line is drawn. And if you look at paragraph 90...
Sorry, just before you, thinking around the significance of that. Of course, the POEM tests only matter if you've established residence. And the CMC type tests tell you about residence. On your hypothesis, those are relatively clear. So the advisors in London can conduct themselves in such a way that you never get residence here. And if you don't get residence here, you don't have to worry about POEM.
Well, there are different English tests of residence for all sorts of different things. For individual, the test of residence is different to that which applies to trustees, to that which applies for corporate purposes. There are muscular statutory interferences from a corporate perspective, which changes what's meant by residence. If you're incorporated in England, you're deemed to be resident here. That's one of the discussions.
Isn't my Lord's point that if it's a tiebreaker, it's a tiebreaker between two regimes where you've got residence in both.
Automatically.
And so
yes,
you've got to have residence before you move on to the tiebreaker.
But let's say, for example, you're here by virtue of incorporation and you're in Mauritius by virtue of incorporation. When do you cross the line for effective management moving from one of the eminent legal firms or accountancy firms in the City of London, which every day of the week advise upon the proposals to, in a tax efficient way or a corporately efficient way, reorganise matters, so that you end up dragging onshore a structure which is not here. Consider, for example, this case vividly illustrates the facts of that. Let's imagine you're dealing with a flotation in these circumstances. The number of lawyers and accountants involved in providing advice as to how you effect a merger and flotation with the sophistication that the FTT identifies in this. This is what law firms in London do. And if you have a non-resident company, a French pharmaceutical company, that wishes to list on the New York Exchange or wherever it may be in relation to it, if taking advice from a set of advisors, a merchant bank or a law firm or accountancy firm in London is such that, and you follow that advice, or your proposals are made which you adhere to, as to render your effective management to be being done at number 1 Embankment Place or wherever else it may be, then there are real concerns that arise from that.
I dare say you're right, but just to see if we can get an example. As you say, you have to envisage a situation where applying the tests operated by the two countries, you end up with potentially rival claims.
Yes, my lord.
So we've got our French company, our French pharmaceutical company, being advised from London. What connecting factor might make it, in principle, liable to UK tax?
Well, let's test it the other way around, my lord. Let's say, for the sake of argument, just for the testing the hypothesis, that actually what we're testing is central management and control. And let's assume, in my favour, that central management and control in POEM is the same test for these purposes. We still have, POEM is still in all the treaties, it just comes lower down the tiebreaker provisions in relation to it. Let's assume it's the same test in relation to it. Now, if that French pharmaceutical company, there's no, let's assume, for the sake of argument, it has a subsidiary in London or something, which gives it a registration residence here, so that we've got a tiebreaker or otherwise to deal with for these purposes. And what we're looking at is listing the subsidiary in relation to it. Let's assume that we go off to, not the BBC, but let's assume we go off to Goldman or to Deutsche Bank and to Freshfields and Linklaters and to BDO and to PwC, and we get advice as to how to list this and what the flotation mechanism needs to be. And there's a beautifully executed plan to float these shares in relation to it. A number of steps need to be done to effect the merger or otherwise. I cannot, on any principled basis, establish why it is that my learned friend's approach to the establishment of a place of effective management would not render you unsure, if that's right. And what the CMC test, which is familiar with these issues, does, is said, look, having a tax plan or having proposals that are put to boards who meet in their constitutionally proper place to make those decisions won't drag you onshore.
And just to be clear, why in that situation wouldn't the CMC test prevent one getting to POEM?
Because it's incorporated here. So it's an English incorporated subsidiary that's being managed in France.
Yes, I see.
Seems a bit odd to be applying a test for residence in circumstances where that test is not required because it's resident on the basis of incorporation.
Well, in a sense, and we'll come on to this in Smallwood, my lord, if the test of central management and control it was described as a tool by the Upper Tribunal. I'm not quite sure whether that does it justice or otherwise, but what it says is the residence of a company for general common law principles is the place in which its constitutional body meets and makes decisions according to that, except for these sets of circumstances. My place of effective management test would do exactly the same thing in those circumstances. And the mere fact that it's been used for 100 years in England to resolve the question of whether you're in England doesn't mean that it couldn't equally serve a dual function of perfectly acceptably resolving.
My question's a much more basic one. Sorry, this is due to my lack of understanding. If incorporation is sufficient to give you residence, why do you need CMC at all?
On the facts of that particular case.
So the reason why we get into this question is my Lord Justice Newey was asking you, how does a poem test help as a tiebreaker if the issue doesn't? Why is a tiebreaker needed if you've got no residence in the first place because you failed the CMC test? And you said, well, it could still be applicable because there might be residence on the basis of incorporation. And so that's where I come in and say, well, in that case, why are we looking at CMC at all if incorporation is enough?
I think the point that possibly I fear I'm missing the point, my lord. The point that I'm making in relation to it is CMC is predictable. It is objectively understood. There's an enormous body of case law that supports it. And in the context of a poem test...
You're no doubt right about saying CMC is relatively predictable, but incorporation is even more predictable. Yeah. But the question that we're struggling with, or at least I'm struggling with, is the circumstances in which you need a tiebreaker and what the role of a tiebreaker provision is. Yeah.
Let me give you... I'm not going to do it by reference to the Mauritian Treaty, but let's assume for the sake of...
Because if I'm only repeating what we've already said already, but ex hypothesi, if there's no residence in the UK, you don't need a tiebreaker. The question only arises where you've already established that there is residence.
Yeah, well, there may be residence at different points in the course of different tax years.
Well, it has to be residence at the relevant point in time.
At some point in time, yeah.
Well, me coming to this relatively unsullied by any knowledge, I'd understood that the CMC test really applied when there wasn't incorporation.
That's right.
I'm looking at my Lord's paragraph 14, where he lists all the things, and number 4, something, the company may be resident in a jurisdiction other than that of its incorporation. So that's how you get to have be resident in 2 places. You're only incorporated in 1. And this is a trust anyway, so we're in different territory. But am I right that CMC only comes in if you're not incorporated?
The effect of
and you're seeing whether nevertheless is another residence established.
The statutory regime in England is such now that if you're incorporated here, you're deemed to be resident here for tax purposes. So you don't need to go into the CMC.
But that was not the case in 2000?
I forget when those rules were introduced. I can find them.
No, well, we need to
find the date for it.
But was that why the two of you were slight odds?
I think
you're
Justice
talking
Arnold
about the same thing, but
is pressing me on a different point.
Yeah.
Allied to it, what Justice Arnold is saying, look, in circumstances where, I hope I've got the question right, in circumstances where you have, you're deemed by the muscular operation of some registration rule, or you're listed in a country, that therefore you're deemed to be resident there, or you're incorporated there, you never get into CMC. And so in what circumstances would ever you be in the tiebreaker scenario that would require you to apply poem if you're deemed to be in one place rather than the other?
Well, that's one half of the coin. The other side of the coin is you only need poem if there is residence in the UK, because if there isn't residence in the UK, whether you're applying a deeming provision based on incorporation or whether you're applying the CMC test, the question doesn't arise.
Yes, that's right, my lord. But I think that the residence and the difficulty with it is, and it's illustrated in the present case, that there are certain provisions of the English tax code, and no doubt equivalent ones in other tax codes, that have to deal with all sorts of circumstances. They have to deal where you're resident, not by reason to something obvious like incorporation or otherwise, for a few days in a tax year. They need to deal with circumstances where Mauritius deems you to be, or Xanadu deems you to be resident for...
Yeah, but I don't think we're concerned with those kind of exotic considerations. But where this puzzlement becomes relevant, I think, at the moment, is if you've applied CMC to determine that the body in question is resident in the UK, how can you then use the same test as a tiebreaker?
Well, I think that's, my lord, I think that's possibly, I'm going to be, I think carefully how I put my answer to that, but I think you see a vivid illustration of it, actually, in the context, for example, of the Mauritian Treaty. It is not, in my submission, at all inconceivable that the effect of the terms of the treaty was such that if you were deemed to be resident in Mauritius because you were registered there, for example, and you were deemed to be resident in England because of the CMC test, the treaty will yield to England. It was just saying that the CMC, we're much more interested in the substance of what's going on than we are with all these legal niceties. And call it colonial arrogance or otherwise, that was the terms on which we negotiated our test took all. A criticism I will have of the Special Commissioner in Smallwood is that he felt that in circumstances where CMC was not requiring you to make a choice between two different, historically, not being requiring you to make a choice between two different jurisdictions, it was just asking whether you were in England or otherwise, it was doing something slightly different. But my submission is that it could serve two functions perfectly well.
So, Mr. Rupert, does that tantalisingly get us to Smallwood just a minute before 1 o'clock?
My lord, yes, I think it. In fact, it does, my lord.
There we are. There we are. So, how are we doing on your time estimate for finishing towards the middle part of the afternoon?
So, my lord, what I was proposing to do after lunch, I need to deal with Smallwood in some detail.
Yes, of course.
And I will spend quite a bit of time just explaining what I say Smallwood stands for. Then I need to meet the tests as to why I say it's not binding upon you. Or alternatively, why I can invite you to depart from it. So I would hope I'll be done. An hour may be optimistic, my lord, but it won't be an awful lot.
I think we'd welcome hearing from Mr. Stone at least opening his submissions this afternoon. Yes.
Thank you, my lord.
Good. Well, whether the sales of unseasonable sales of sweaters go up in Fleet Street over lunch, we wait to see. But we'll be back at 2 o'clock.